Welcome to today's video. We're unpacking a costly misconception in immigration court, that your case automatically moves when you do. We'll explain what actually happens to venue, what you must do if you relocate, how motions to change venue work, and how to protect yourself from missed hearings. Let's begin by outlining our roadmap so you know exactly what to expect. Here's our agenda. First, we will debunk the automatic transfer myth. Next, we will define venue and explain why it is sticky in immigration court. Then, we will cover mandatory actions if you move, followed by how to file and evaluate a motion to change venue. After that, we will use diagrams to visualize decisions, timing, and risks. Finally, we'll test your knowledge and summarize the essentials. To transition from assumptions to facts, let's confront the myth head-on. The idea that your immigration case automatically follows you to your new city is misleading. In practice, venue in immigration court is sticky. It stays at the original court unless it is formally changed. Now let's clarify exactly what venue means and why it rarely moves on its own. Moving forward, here's the core reality. Venue is the designated court location for your immigration case. It does not automatically change if you move. While there are rare exceptions, such as certain detention transfers or closure of the original court, these are uncommon. The Executive Office for Immigration Review prioritizes efficient adjudication. If you show up and are prepared to proceed, judges seldom compel a transfer solely due to your new address. Therefore, treat your original court as your official venue unless you receive a written order that changes it. Before we go further, a brief but crucial disclaimer. This video is for educational purposes only and is not legal advice. Rules and procedures can change, and individual facts matter. For any decisions about your case, consult a qualified immigration attorney licensed in your jurisdiction. Next, let's shift to the mandatory steps after moving. First, file your change of address without delay. For EOIR matters, use Form EOIR 33 for the correct court, or for the Board of Immigration Appeals as needed. If your matter also involves USCIS, file Form AR11 to update their systems. Second, continue appearing at the original immigration court for all hearings until a judge formally approves a change of venue. Third, monitor your mail closely. Failure to receive a notice due to an outdated address can lead to an in absentia order, which is a removal order issued in your absence. Fourth, keep proof of filing and delivery for every submission. Fifth, inform your attorney of your move, and regularly check your case status to avoid surprises. Now, step by step, here's how to file a change of address properly. First, confirm which court has your case by reviewing your hearing notice or checking EOIR's automated system. Second, obtain the EOIR 33 form that corresponds to your specific court. Third, fill in the form carefully with your full new address and your A number. Fourth, serve a copy on the Department of Homeland Security Council as required, following service rules. Fifth, submit the original to the immigration court using the filing method the court accepts, which may include mail or, where available, electronic filing. Sixth, keep all proof of submission, such as certified mail receipts or electronic confirmations. Finally, verify your address update after a few days using the EOIR hotline or online portal to ensure it was processed. Let's visualize the decision-making process. The flowchart begins with a simple question. Have you received a written order granting a venue change? If yes, you attend the newly assigned court. If no, the next question is whether a hearing has been scheduled. If a hearing is on the calendar, you travel to and attend the original court. If no hearing is scheduled, you continue to monitor your mail and case status and prepare to attend the original court when a date is set. A side branch shows that even if you filed a motion to change venue, you must still plan to attend the original court unless and until the judge issues a written order approving your request. Turning to venue motions, a motion to change venue is a formal filing requesting that your case be reassigned to a different immigration court. This request is not guaranteed, as judges have broad discretion. In today's high-volume environment, courts are mindful of shifting backlogs and added administrative burdens. To improve your chances, support your motion with concrete evidence of your new residence, such as a lease, utilities, employment or school records, and any medical or hardship documentation. Explain logistical benefits, including the locations of you, your witnesses, and your attorney, as well as interpreter availability. Demonstrate that transferring the case will not cause undue delay by showing your readiness to proceed. Despite filing, continue attending the original court until you receive a signed order granting the change. Let's compare the common misconception with the correct procedure. On the left, the automatic transfer belief involves no formal request or evidence and often results in missed notices or even in absentia orders. This is generally not how EOIR operates. On the right, a motion to change venue is a structured legal request supported by documentation and legal arguments. It may be granted at the judge's discretion, but until a signed order is issued, you must continue to appear at the original court. This table offers practical expectations. A recent move supported by strong proof may lead to a medium likelihood of transfer, but outcomes vary by judge and docket pressure. Health or documented hardship can increase the odds. Motions based purely on convenience are often denied because they do not address efficiency. When your attorney and witnesses are all located near the proposed new court, you might achieve a medium likelihood, particularly if it will streamline the case. By contrast, a motion filed right before a hearing is frequently viewed as causing delay and may be denied. To add timing context, the timeline starts at your move date, followed promptly by filing the EOIR 33 and serving DHS counsel. You then verify that the court updated your address. If a venue change is appropriate, you file the motion with supporting evidence. During the waiting period, you continue to plan to attend the original court. Finally, on the hearing date, you appear at the original venue unless you have received a written order approving the transfer. This pie chart highlights common pitfalls. The largest slice represents missed notices caused by failing to update the court with the new address. Next, assuming automatic transfer accounts for a significant portion of problems, filing a motion too late, ignoring a scheduled hearing, and failing to properly serve DHS each contribute to adverse outcomes. Understanding these proportions helps you prioritize actions that reduce risk. Quiz time. The question is, true or false? When you move to a new city, your pending immigration court case automatically transfers to the nearest court. The options are true and false. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is false. Venue does not automatically transfer when you move. You must seek a change through a formal motion, and you must keep appearing at the original court until a written order grants the change. Here is your second quiz. Which two actions are mandatory after you move while your case is pending? The options are A. File EOIR 33 change of address. B. Attend hearings at the original court until venue changes. C. Wait and do nothing until you get a new notice. D. Skip the original court if you filed a motion. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A and B. You must file your change of address promptly and continue attending the original court for all hearings, unless and until a written order changes the venue. Let's consolidate the essentials. Venue remains at the original court until a judge orders otherwise. There is no automatic transfer when you move. Always file EOIR 33 to update your address, and if USCIS is involved, file AR 11 as well. Continue attending the original court unless you hold a signed order changing venue. Remember that a motion to change venue is discretionary. Support it with strong evidence and emphasize that the transfer will not cause delay. As a quick reference, here is a concise checklist in Markdown style. First, file the EOIR 33 for the correct court promptly. Next, serve DHS and keep proof. Then, verify that the court updated your address using the hotline or portal. Prepare to travel to the original court if a hearing is scheduled. If you plan to request a transfer, file a motion with strong evidence and explain how it will not cause delays. Finally, keep organized records of every filing and notice. In closing, remember that venue does not automatically follow you after a move. Plan to continue attending the original court. Update your address immediately and monitor your mail closely. If you want a different court, file a well-supported motion and set realistic expectations. Documentation, timing, and readiness are critical to success. Thanks for watching. If you found this helpful, please like the video, share it with someone who might be moving during their case, and subscribe for more plain language immigration explainers. In the comments, tell us where you are in the process or what topics you want next. Your questions may shape our next video.